All right. Very good afternoon, ladies and gentlemen, wherever you are joining us from. We hope you're having yourselves a very lovely afternoon this beautiful Thursday afternoon, and we thank God that the week is coming to a very perfect close. And as such, we would like to welcome you on behalf of the East Africa Law Society for yet a very wonderful session. And this afternoon, we are discussing nothing else but the tension that exists for a lawyer working within public service. And our session titled Public Servant or Lawyer, Ethical Tensions, Professional Duties, and Career Consequences for Government and Public Sector Lawyers in East Africa. Now, we all agree that there, in a way, exists a certain tension, and this tension sometimes causes a bit of issues for most of us in that space. And we have our esteemed panelists on board this afternoon, and in particular, I'm honored to invite our moderator, Miss Nicole Chihara, and Nicole here is an advocate of the High Court of Kenya with over 7 years' experience in litigation, commercial transactions, banking law, debt recovery, conveyancing, corporate legal advisory, and she currently serves as in-house counsel at KPLC. She provides strategic in-house counsel, managing complex litigation and supporting corporate governance, compliance, and risk management. Now, Nicole has a proven track record of safeguarding organizational interests, resolving high-value disputes, and delivering practical legal solutions that drive business objectives. Nicole is a woman of many hats. If I start introducing her, I may introduce her till it runs late. But Nicole, karibuni sana. We are honored to have you and honored to have all our panelists this afternoon, and I invite you to take on the session now. Asante.
All right. Thank you so much, Gabriel, for the lovely introduction that you've given. I feel very honored, actually. And welcome our lovely participants. Thank you so much for taking time and an opportunity to join me in to just discuss the public servant and the lawyer first. Right, thank you so much. This session has, we are blessed to have very well-established panelists who are going to talk about the lawyer and the public servant and the lawyers practicing in that section. I'm made to actually realize this is the first of its kind in the East African Law Society. So it's such an honor and privilege to have this conversation running. And just to kickstart this conversation, I know the role of the government and the public sector advocates occupies a very unique and often challenging space in our legal systems, both if it's Kenya, Uganda, wherever we are within the East Africa. And where one thing that is very common is that we're not only called upon to serve the institutions, but also to uphold the very integral legal systems that are in place to protect the rule of law and also safeguard the public resources and advance the broader public interest in its entirety. And one thing to notice that when we continue our responsibilities, we encounter various challenges. And now that begs some of the questions. Along the way, we are faced with a lot of challenges and some questions along the way. So some of the questions which we both may agree on is, how do we balance the independence of our professional independence and yet uphold the institutional loyalty? How do we as advocates render legal advice that may conflict with maybe the institution discrepancies? Then how can we also deal with ethical integrity but at the same time maintain the environments which we currently, or rather the public advocates sit on? So those are not merely theoretical questions. Those are actually questions that public service lawyers or advocates facing. And the panelists are here. We have 3 of them who will tackle them in various topics. Allow me to introduce them to you, ladies and gentlemen. One of them is Dr. Kanchuri, And we have on the panel as well, we have Ms. Nduta Njenga, and last but not least, we have Lucas Malunde. We'll give them an opportunity to just give us a brief introduction of who they are. And maybe you can start off with Dr. Daniel Kanchuri. Karibu sana. Maybe you can give a brief summary of who Dr. Kanchuri is.
Are you able to see me? Can you hear me?
Yes, we can. Yes, we can. It's now clear.
Good afternoon. My name is Dr. Daniel Kanchuri, an advocate of the High Court of Kenya, managing partner, Kanchuri Mutali and Company Advocate. I have experience of over 7 years, and I'm glad here. I've served in several government agencies, and I think that's why I was chosen for this topic as a government advisor at some point. So I come from Kenya. I'm Masai, proudly Masai. Asante.
All right. Thank you so much for that introduction. I guess once we get to hear the introduction from our lovely panelists, we will get back to you on the questions we want urgently addressed. So Karibu, welcome, Ms. Nduta Njenga. The floor is yours.
Thank you very much, East Africa Law Society, for extending this invitation. Thank you to my co-panelists, and thank you to everyone participating in this webinar today. My name is Duta. I practice as an international development professional, but I started off in public sector, specifically at the Ministry of Energy and Petroleum in Kenya, where I advised on energy sector governance. I have also worked in a similar capacity at Ethiopia's Ministry of Water, Irrigation and Energy. And I have about 7 years experience in public sector. I am very privileged to be with you today, and I hope it will be worth your investment in time. Thank you.
Thank you so much. Thank you so much, Nduta. I really appreciate it. It's good. We are really honored for you to join this panel, and we look forward to your presentation here. Karibu sana. I don't know if he's there. If he's there. I'm not going to see him. Mr. Malunde, are you there? Mr. Malunde, are you there? Mr. Malunde, just to keep the conversation running, he will basically talk about the, excuse me, he'll just talk about the practical realities of serving as government advocates, and now which will include how to navigate the hierarchies and the political dynamics and protecting the professional integrity, managing the risk exposures and make informed career decisions, and how to navigate that space. So I believe he'll be able to join us shortly. But let's start this conversation. We'd like to now get back to Dr. Kanchuri, who will just set the foundation to us, just examining the ethical responsibilities of government lawyers and how to navigate the issues about the advice, and what about talk about the issue where there's a conflicting interest, where the institution may have one trail of thought that they insist that they want to pursue, which may go contrary to the legal advice that we so know. So maybe Dr. Kanchuri will be able to advise us on the same and do a presentation on the same. And I'd like this opportunity to welcome him. Dr. we have 15 minutes to just make that presentation, and we look forward to it. And even as we do so, we would request that if there's any question that you may have during the presentation, please write it on the chat box as well, and we'll be able to capture it and answer it at the very tail end of the 3 presentations that the panelists will have. I think that's in order. Then we can take it away. Dr. Kanchuri, karibu sana. Welcome. Is everything okay with you, Doctor? I think you're muted. We don't seem to hear you. All right, as we wait for him to sort out the issue that is the issue.
Are you able to see me?
Yes. Now we can hear you.
Can you see my screen?
It's coming shortly.
Are you able to see the screen?
Just a minute. It's not yet. Yeah. There we go. Now you can see your screen. Yes, we can now see your screen.
Okay, thank you very much. My name is Dr. Daniel Kanchori. I'm going to take you through the Government Lawyers Ethical Compass, balancing public duty, professional independence, and institutional loyalty. First and foremost, it's a delicate position. Government lawyers operate where there is public interest. There is also political agency, and we have the institutional pressure. The constitutional duty collides. So their role is not merely to defend government action. It is to help shape lawful government from within. We have three duties. That is public duty, protect the public interest and uphold the constitution. Number two is their professional independence from legal judgment on law. You must apply the law. You must have evidence and also the principles. But the last but not least is institutional loyalty. You must serve the state faithfully, but never as an instrument of illegality. Article 156 of the Kenyan Constitution, we have the rule of law, which mandates in Kenya the Attorney General, basically, who is the chief government advisor, to promote, protect, and uphold the rule of law and defend the public interest. Government legal practice is not limited to defending government action. This one requires understanding the state as a constitutional entity on its own, and not merely the office holder or the political administration giving instruction. So you must view the government as an entity and not just the office holder. This is key. Ethics in ordinary government work, for example, in a county level, where I was privileged to serve as an advisor, we have the lawyer advising on the finance bill, procurement, the land use decisions, and local legislation. They are all subject to constitutional procedure. And this falls into public participation, which our courts have pronounced themselves not just being ceremonial steps, but there are constitutional safeguards that requiring affected communities to be notified, heard, and meaningfully considered. Then we have the political agency, where some decisions may carry public pressure, but must still must comply within the constitutional procedure. The lawyer's duty begins before the final decision and not after. So as a lawyer, you are not called to make a decision or give advice after the decision is made. It has to be before. And then we have the lawful policy. The government lawyer may properly defend lawful policy choices, even when they are unpopular. But institutional loyalty cannot require participation in illegality. It's very important to note that. We have some important landmark decisions. We have the Finance Act of 2024 in Kenya, where there was imperative revenue agency, and it colluded with public participation requirement. But the deeper lesson, guided institution before enactment, not after. That is actually the challenge. We had the BBI, where there was a political consensus, which sometimes can fail and deviate from constitutionality mandated procedure. But political momentum cannot cure constitutional defects. We also have the Huduma number case, where the matter of policy framed around efficiency, modernization. This one required data protection, impact assessment before the implementation could continue. And there was a ruling, it was not a rejection of innovation, it was a reminder that modernization must also comply with data protection standards as constitutional safeguard protecting personal privacy. So we had the institutional loyalty demonstrated not by defending every initiative at all costs, but ensuring innovation are lawful and rights respected. Yes, I also have the boundaries of institutional loyalty. A government lawyer owes genuine loyalty to the institution. Nothing can be further from that. But that loyalty is bounded by legality, professional ethics, and the wider public interest. We have what is permissible, defend the law, the lawful policy choices, even where unpopular or personally disagreeable. Sometimes as a lawyer, you don't agree, but they are lawful, they are within the law, they are not popular, but that one is permissible, you must defend it. What is impermissible is participating in illegality, misleading courts, concealing wrongful doing, or rationalizing unconstitutional action. Then we have the standard. Duty to government is a duty to its lawful authority, not to every instruction issued in its name. That is the standard that every lawyer must comply. Then we have the cost of professional independence. It comes with a price, must carry the cost. And this one requires a legal judgment, must be formed on law, evidence, and principle. Not fear, not ambition. Sometimes you might have ambition, so you want to please the power that be, or political pressure. This is especially difficult where the client and the employer are one and the same. There is the real risk. A government lawyer offering unwelcome advice may face transfer, isolation, stall career progress, or reputation damage. They can open your files so that you can comply. Then we have the demand. The role demands can do. That is especially when asked to justify finalized decisions, defend legally weak position, or remain silent about legality concern. That is another demand that is there. The regional dilemma. Across East Africa, we have government lawyers operate under difficult legal framework while confronting the same essential ethical question. How does one serve a government faithfully without reducing legal practice to an instrument of political convenience? A very big question. The answer cannot rest on a falsy binary. The government lawyer must be both a public servant and a lawyer. But when tension rises, professional obligation must guide. The ethical compass that you must hold, public duty. You must be committed to the Constitution, the rule of law, and public interest. Professional independence, honest legal judgment, especially when that judgment proves unwelcome. Then we have the institutional loyalty, diligent service to lawful government objectives, never blind obedience. The professional face a choice. That's either to remain truthfully professional or to become something less. Whether this balance can be sustained in Kenya and across East Africa will determine the sector's legal practice, credibility, and integrity. Key takeaways, but I think they are important for a lawyer. One, do not define the client as a political office holder. Define the client as a lawful public institution. You must always have that in mind. Number two, defend lawful policy choices, but do not sanitize illegality or constitutional defect. Give legal advice early enough to shape decision, not only after litigation begins. Treat public participation, procurement integrity, data protection, and accountability as substantial legal requirements, not formalities. The other important thing is maintain professional independence, even when honest legal advice may affect your career. Last but not least, we must build regional ethical guidance and support system for government and public sector lawyers facing institutional pressure. Asante sana.
Thank you so much, Dr. Kanchuri. Thank you so much, Dr. Kanchuri. Allow me to ask, even as thank you so much for your presentation, maybe just to have this further to your presentation, have you ever experienced such friction and how did you go about it? That would even give us better insight on how you have approached this issue of conflicting, various conflicting issues between now the public institution, their decisions on how to go about it, and yet you have a legal obligation to uphold the rule of law, and the action and the decisions they want you as an advocate, lawyer to do is conflicting with the legal beliefs. Do you have any example to that effect?
Absolutely. I served as a legal advisor to the county government of Kajiado. And a practical example is when we had an RRI. The term of the government then was coming to an end, that is in 2020. And we had to move very fast to ensure that we have a record that the government has delivered vis-a-vis the actual performance on the ground. And as a head of the RRI then, I advise that you cannot say a project is done well, actually it has not been done. When you have some code officers, they want to say that this has been done, the project is complete. So I had to send a team on the ground to actually take pictures, that is the evidence, get the certificate, is the contractor raising the right certificate vis-a-vis the work that has been done on the ground. So I was able to mitigate between the political pressure to show performance and the actual work on the ground. For sure, I stepped on many people's toes, but I was within the law. And I had facts, I have evidence. So that's an experience that I went through.
All right, thank you so much. And what would, I know I had mentioned that conversation, the questions be put out on the chat box and deliberated at the end of this, the presentations, all the three of them. But is there anyone that, yes, you've given an example of how you were able to address, and you have said that you have dealt with very many conflicting incidences. Has there been one that, you had given your advice, the institution that you were serving had completely disregarded the advice you gave, but later on regretted and had adverse implications on the same?
Thank you very much. The other was on issues of vetting. You know, when you have a candidate who has supported the government politically and he needs to be pushed through to be vetted in parliament, but there are integrity issues or some concern or even qualification. And but huyu ni mfuasi. This is the person who has contributed immensely on the ground. They ended up facing rejection in the assembly. So there are consequences for not taking legal advice, and the candidate actually suffered. They thought maybe I am not for the candidate or I have personal reasons, but it was based on the political balancing, the political pressure vis-a-vis the requirement for suitability of that candidate.
Thank you so much, Daktari, on the same. Thank you so much. Allow me to go to introduce the next speaker, or rather panelist. As introduced, she is Ms. Nduta Njenga. She'll be presenting basically on the segment of professional responsibility. Where do we stand as in-house counsel in the public sector? When we prepare that opinion, what do we look out for? What are the loopholes that we need to address? What are our achievements? And what are the, when you're especially handling high and very sensitive matters, how do we go about it? So I think Ms. Nduta Njenga will effectively deal with that issue as well, and also address the issue of candor. How are we supposed to address what is our duty of candor? What is the fidelity, constitutional fidelity? And how do we maintain professional independency in a place or an institution that may be politically, a very political space in it, and dealing with a lot of institutional pressures? So welcome, Ms. Nduta Njenga. You have 15 minutes to make your presentation. I hand it over to you.
Thank you very much, Nicole. Please confirm that you can see my screen.
Yes, I confirm. I confirm I can see your screen.
All right. Thank you very much once more. And good afternoon, everybody. I have been asked today to discuss the topic legal opinions, constitutional advice, and the duty of candor. My goal today is to leave you with something to reflect on, not just as a legal practitioner, but also as a human being navigating life. The question of what a government lawyer should do when asked to produce an opinion that justifies the unlawful or the unconstitutional is, in my view, not a technical question, but a moral one. Therefore, if we approach it only as a technical question, we will miss something essential. Before we examine the character of the law, I think we should begin with examining the character of the lawyer. And I would like to do this through the lens of three fundamental questions. What is a lawyer? Beyond what the license says, but rather what the role was always supposed to mean. A practicing certificate makes you a licensed legal practitioner, but it does not by itself make you a lawyer in the true sense of the word, or in the sense that matters for today's discussion. That distinction is what I want to speak about over the next few minutes. The second question is what happens when that meaning is eroded? And number three, how do we reclaim it? Now, the credential definition of a lawyer is almost entirely hollow as a moral category. Allow me to give you a brief history lesson about the original meaning, or on the original meaning. The Roman jurisconsult held that a lawyer is one with authority, not from a license, but from demonstrated fidelity over time to principle over convenience. The English common law tradition from which our jurisdictions draw their legal backbone, gave us the officer of the court. And the duty of the officer of the court is to the system of justice, which is itself a system of integrity. And this system is independent of any client, of any employer, of any government. The lawyer was always seen as a public figure, even when they were practicing privately. However, this definition has been eroded or bastardized in three specific ways. The first one is through instrumentalization. The lawyer has unfortunately been recast as a tool, albeit a sophisticated one, which is available to whoever can command or control the tool. Number two, the credentialist inflation, where the certificate is confused with a vocation. So one has a license which says you can practice, but it says nothing about whether you will practice and how you should practice. The third is through institutional capture, which I believe really is quite insidious and to which the government lawyer tends to fall. And here the lawyer is socialized into the institutional logic. And so what happens is that they end up thinking of themselves as government officers who happen to hold a law degree instead of lawyers who happen to be working in government. And once this institutional capture happens, the rest follows automatically. And the effect is that the uncomfortable opinion is not written, the irregular transaction is facilitated, and it's not necessarily out of corruption, but simply because the lawyer has forgotten who they are. And the truth is, character deficiencies will always undermine even exceptional abilities. The erosion of this definition is, in my view, first and foremost, a character problem. It follows then that the quality of the lawyer will always affect the quality of the law. And we know that legality is not and never has been the measure of or a reliable proxy for morality. And we have historical proof. Apartheid, colonialism and colonial dispossession of land, the denial of the vote to women, slavery, all of these were legally structured, they were professionally administered, they were sanctioned by courts, and they were not informal abuses that operated despite the law. They were structured and they were legal, they were administered by lawyers. So when we say that something is legal, we are describing its relationship to a system of rules. We are not, and we must not allow ourselves to think that we are, in fact, describing its relationship to justice. So the government lawyer who is asked to produce an opinion that justifies an unlawful executive act is not simply being asked to bend the rules. They are being asked to be the mechanism through which legality does the work of legitimacy. And these are two different things. They are being asked to lend their professional authority to something that lacks integrity. The cost of this erosion is seen both in the public, and I believe a price is also paid at the personal level. In the public, we have seen procurement processes that are professionally administered, but which are deeply corrupt. We have seen legal opinions that are drafted to arrive at a predetermined conclusion. And as a consequence, public trust has been so eroded that when something is approved by the government legal team, people now know to ask, whose interest does this serve? There is also a personal cost, and something is lost in the lawyer who knowingly facilitates what is wrong. Integrity does not collapse, apologies, all at once, but in the accumulation of small surrenders. What then is justice? And what standard should lawyers be serving? I've mentioned the term justice a number of times, and I think it deserves a definition because everything I'm building I'm building towards depends on this answer. Justice is not the output of any legal system. It is the condition that any legitimate legal system is trying to approximate. And the standard, justice is the standard against which the law is measured, not the standard that the law creates. Law is in itself an instrument. Justice is the end of that instrument. And unfortunately, an instrument can be pointed in any direction, including the wrong direction. Justice is older than any statute, and it is recognizable by conscience long before it is recognizable by code, which is why an ordinary person who has no legal training, who has no legal background, can look at a law and say, this is unjust. And not because they have analyzed any legal frameworks, but because they have consulted something deeper. What does reclaiming the just standard require? And allow me to offer 3 suggestions. Number 1, returning to the understanding that the authority derives from the system of justice, not from the employer, even if that employer is government. Number 2, recovering the identity of the lawyer as both the custodian of justice and as a public servant, rather than as a technician or a mindless tool. It should matter that that a lawyer is a person whose existence guarantees that the law means something. And thirdly, the courage to turn back, both at the individual level and at the level of the office. So the question is not really whether the pressure will come, but what you are made of when it does come. There is a higher standard. And therefore, if justice is not what the law says, then what is it? And I already made reference to this a little bit earlier, and it is in the constitutional architecture of all the jurisdictions that are represented in this webinar today. There are rights that precede the state. Our constitutions do not grant the right to life, the right to dignity, the right to equality. They merely acknowledge what already exists, and at best, their job is to protect them. We call it natural law, we call it inherent dignity, but regardless of the name, we recognize that there are rights and wrongs that exist independently of legislature or what the court can validate. So a legal opinion that purports to extinguish inherent rights is not merely wrong as a matter of law, but illegitimate as a matter of first principle. And so the lawyer who produces it has placed their professional integrity in the service of something which lacks integrity. And this is a shame. The duty of candor, which is the duty to advise honestly, to resist pressure, to resist the temptation to shade or distort legal position, is the practical expression of this principle. The honest opinion, when honesty is costly, is infinitely worth much more than a polished opinion that is designed to arrive at a predetermined conclusion. And Honorable Kanturi has mentioned this in his presentation. The things I've described require something that cannot be taught or bought. And it requires, in my view, genuine conviction. Most government lawyers will at some point face a moment when their professional integrity becomes personally consequential, when the honest opinion is unpopular and most likely quite risky. And that is the moment that you discover what you actually believe. I will refer you to an author I deeply respect who says, you never know how much you really believe anything until its truth or falsehood becomes a matter of life and death to you. And that gap between the public lawyer and the private one, that gap between what somebody says in public and a private standard that they entertain, is where integrity is lost. The same author says, you never know the same author says that it's possible to turn back. If you are on the wrong road, progress means doing an about turn and walking back to the right road. The man who turns back soonest is the most progressive. To me, this is a message of hope. Not all is lost. Even when one has taken several steps in the wrong direction, one can turn back. Therefore, the lawyer who catches the legal error in good time and says something is not being obstructionist. But the one who says nothing because he or she has been persuaded by expediency or pragmatism is not being progressive. They are walking down the wrong road. And unfortunately, institutions, as well. Thank you. Institutions as well as individuals will eventually have to reckon with how far they have walked away from the standard. What does this look like in practice? I came up with a 4-step suggestion that I offer to you to consider. And the first step is separating the request from the opinion. One must acknowledge the legal question without committing to a predetermined answer. Number 2, write for the record rather than the room. So a documented opinion protects you, whereas one that is written to please will eventually be used against you. Number 3, name the tension explicitly. And like Dr. Honorable Kanturi mentioned, you better do this at the beginning rather than when litigation comes up. It is not unprofessional to note in writing that the legal position is in tension with the desired outcome, which is often a political agenda. And finally, know your flaw. Identify it long before the pressure arrives. It's my considered opinion that the most effective public servant is the one who is first and without compromise a lawyer in the original sense of the word, not just one who is credentialed, not just one who is competent, but one who is anchored to something that cannot be captured or intimidated or promoted away. In my view, the lawyer who abandons their professional integrity in the service of the institution that employs them ultimately serves neither. Thank you very much for your attention, and I look forward to your questions.
All right. Thank you so much, Ms. Nduta Njenga, for your lovely presentation. Indeed, that has been very informative. As I mentioned earlier, we'll keep the conversations quite open. We will invite our next speaker first, probably to first go through the presentation. Then we'll be taking this opportunity to consolidate all the questions and then now pose it to the panelists as we go along. Thank you so much, Ms. Nduta Njenga, for the presentation. Allow me to introduce the third but not least. This gentleman is Mr. Lucas Malunda. He'll be taking us on the actual practical realities of the government advocate, how to navigate those conflicts in all practical sense. I believe he'll even give us an practical examples of what he has gone through or what he has seen other advocates and practicing in the public sector go through, and how to protect themselves and protect the professional integrity that they've promised to uphold. When they got admitted to the bar, they swore that they will uphold the profession in high regard. So I would like to this opportunity come Mr. Malunda Lucas to present his come about his presentation. Don't know if he's there.
Okay, thank you. Good afternoon, all.
Afternoon.
Yeah. Do you see the presentation there?
We can't see it.
Can see it. Eh? Okay.
Maybe you can share your screen.
Okay.
even as Mr. Malunde shares the
Yeah.
screen, we'll just as an information purposes, we will share the slides at the end of the session. So we've taken note of that. We will share the presentations. Thank you.
Okay. I've shared the screen. Do you see it? Hello?
Not yet, not yet. We don't
Not
seem
yet.
to see it.
Okay.
We can see you, but we can't see the screen that are you sharing the presentation?
Yeah. I'm
Okay.
sharing the presentation.
Okay. Maybe what we can do as you try to get to see your screen, as you sort out the issue of sharing your screen, you could share it with the secretariat if you're having challenges. Then we try and
Okay.
project it on our part.
Okay. Let me share.
And then in the intervening period, please keep the conversation running. If there are any questions that you have for the past two panelists who have presented, please write it on the chat. We'll take note of the same so that we can actually ask the questions at the end of the session. I hope we'll be able to get Mr. Malunde's presentation in good time. But even then, allow me to just give you a brief intro of who he is. Okay. He has a very, very big CV. As we're trying to sort out the issue, allow me to just introduce him once again. He's sadly serving in the government. He has served as a vice president.
Instead of share screen.
Or you've already shared?
I can share now screen. And now click.
I think as we share, I believe you'll give us your past experiences you'll talk about where you have served and how you'll give us the practical examples of what challenges you have on the same.
Okay.
Yes.
Okay, thank you. My name is Lucas Charles Malunde. I've been working with the government more than 20 years plus. But at the same time, I'm an advocate. This is according to the law for land, it allows public servant also can be an advocate. Then from there's where now I will try to navigate the experience which I've experienced during my career as a public lawyer, but at the same time as an advocate of the High Court, and the court is subordinate there too. So I'm a public lawyer at the same time as a private lawyer. Now, when you are a public lawyer, you should know the environment in which actually you are trying to live in. The government lawyer and the environment actually which they operate lie within the intersection between the politics, public service, and the law. So to understand the environment can assist you to know how to navigate. In absence of that one, always you'll find yourself, you are outside the Lord. And within that environment, which actually as a public lawyer you're operating, there are some limiting factors which actually they control your career as a professional. You can find there's a bureaucratic structures, political influence, but also resource consent and public accountability. Actually, this I'm talking about the environment in which I'm operating out, which actually almost similar to other African countries. And to navigate in that one, there is no a very, very clear answer which everyone can use to reach at the end. But we have a common principles as a lawyer. You have to observe as that you have a duty. You have a duty of care to your client. And this one is the one actually will guide you as a public lawyer when serving the public. And it's not as simple like the one it sounds. It depends on the way actually yourself, you have developed your strategy on career management and ethical silence. You need to balance the two so that at the end of the day, you have to deliver. Now, when you are delivering within public service, then you have to ensure always you are developing yourself to acquire new skills. But in networking, sometimes you can meet a situation in which yourself, you find yourself like you are on a corner point, and you don't know how we are going to go out of it. But you have the law, and you have to advise. So you have to come out of this one. It depends also on the strategic position. You have positions yourself, and you are silence planning on delivering your service within the public service. In one of the strategy in the ethical resilience on practice is always whenever you advise, your advice should be grounded into legal principles and the constitutional mandate of what you actually are trying to advise. And you don't labor much on what the decision will come out from the advice you have provided by because the decision makers, they have their own, they want to make a decision. But sometimes the decisions they are making not necessarily should be in conformity with whatever they advised. So you stand on a position which at least will give you a hope. When you have delivered your advice, depending on the constitutional principles, depending on the legal principles and the law, and that is the only weapon you can use as a public servant. And it depends also how are you managing your conflict of interest on the issue. Because if you advise on a matter which yourself you have a conflict of interest, it obvious also you are part of the society you are living in, and you have to advise depending on what is required for the public. not what is required for you, for the survival of the public, for the survival of as a whole in general, because you are custodian of justice. You are custodian of justice within the government. So you have to advise what actually will make the government serve the public in good faith. And even when you can find yourself that there's somebody giving you an information which you see it go out of line, you should know where you have to report the matter. Don't liberate it yourself on your shoulder. Accountability. You should know actually at the end of the day, you are accountable for what actually you are advising. You are accountable for any decision you are making on the matter. And one day, if not today, you have to count on it. Morals sometimes, yeah, morality, in some instances, you can find yourself, you have to advise beyond morality. It's about what the law is and not the law ought to be. But in sometimes, you have to advise based on morality. So what is important is what advice is it leave. I've advised it based on constitutional principles, based on a law. That is all. Ethical decision framework also is one of the important in public service, because the ethical framework within public safety are coached on the ethics and the code of conduct of a public servant. Then you should know that one. Me as a public servant, not only a lawyer, I'm a public servant. So the ethics and the code of conduct within the public is a paramount when I'm delivering my duty within the public service. So it's not about you are a lawyer. You should note that also you are public servant. And the public servant should defend according to the public service ethics and the code of conduct. And whatever you do, whatever you conduct, this one should guide you. And within the public service, there are also professional ethics and code of conduct. A good enough, if not bad enough, they are coached within the framework of the ethics and code of conduct within the public service. So if you know the ethics and code of conduct of public servant, automatically, even the professional ethics and code of conduct will be easier for you too. So now the problem starts where now you have to uphold your professionalism out of the box of the public service. And when you are delivering based on professionalism and you are guided with professionalism out of public service, now is where you'll find yourself difficult to maneuver within the public service. Because in one sphere, you can find that you have no limit. You can put everything, whatever you want. But on another sphere, another box, they are limited with what is public interest. Now, your advice should consider what is public interest dictate for me to do. Now is where now the problem starts, and probably is why the tops here actually seem to be very interested to people to see how a public servant, a lawyer within public service, can do lawyering at the same time remain to be a public servant. But the only thing is that you should know the environment you're operating within it and how to maneuver within that environment. Public interest is paramount. Constitutional and legal principles should be the guiding point. Whenever decision you are making, public interest is paramount for any advice you are providing with. But while you are doing the same, there are some challenges you can find yourself within the same. You can find limited resources, but you are under pressure and you have to provide opinion, provide advice within such pressure, limited resources, and to ensure that the government is going on. These are some challenges actually always you'll be found in. And sometimes you can, when if you are given a position now to provide an advice, like a person who is on a private side, you can find yourself sometimes the time for you is limited compared if you could have been attending a private client outside. But also not only the time, the pleasure, the influence, and the resources to deliver what is expected. All also are challenges which you always will be found within the field. But all in all, as a government, you should be equipped with management strategy, ethical resilient, and always sustain into effective public services. And all of this one need always development, skill development in new issues which are evolving. You should also form a network. Sometimes the other issues you will find yourself, you find a way to navigate because you have a network, then you have to share with your colleagues with experience. You know, in a public service, and specifically I'm trying to see only the country I'm operating. A lawyer, if you're a lawyer, you are a lawyer everything. So sometimes you'll be found yourself, you have to advise on an area which need a specialized skill or a certain skill. Then if you don't have a network, you will find yourself you're not in a position to deliver to such an experience. Otherwise, is what I can share. Then we can we'll have time to answer and to share experience with the others. Thank you.
Thank you so much, Mr. Malunde, for that presentation. I believe we can now proceed with the questions for any of our panelists. We have been asked, one of our listeners, attendees, they've asked, what are the this is now for this, it can be taken by any of the panelists, because this they have touched in general for all. What are the practical skills and techniques needed in maintaining professional independence? Maybe we can start with the doctor. Then now we can go to Ms. Nduta and back then to Mr. Malunde. Then another question that has been posed.
Please repeat the question. Sorry. Please repeat
Okay,
the question.
we've been asked by Mr. Onwang, Sam Onwang. He's asked, what are the practical skills and techniques needed in maintaining the professional independence? That's a question by Mr. Sam Onwang. We have another question by Mr. Emmanuel Masanja. He says an advocate is usually retaliated against by his supervisor upon exercising his protected activity. He has 3 questions. He goes ahead and asks, where should he file his retaliation lawsuit? He needs to clarify where he would be, which country is located to advise accordingly. Number 2, should he necessarily sue his retaliator in his official capacity, or his best advice to sue him in his personal capacity? And number 3, do we have a workplace retaliation case or precedents in East Africa? So that's a question by Mr. Masanja. Maybe he could type to us under what country he is in, so that we'll be better advised to address the question. We have another question, or he says he's from Tanzania. So, Mr. Malunde, this would be a good question for you to address because this is your area of jurisdiction. And then we have another question. Let me just try and go up. There was a question here I spotted by Mr. Majok. I'm trying to get his other name. And he asks if a boss, maybe I can just give Mr. Majok's question, then I can go to the rest. And maybe we can address those questions. I hope your panelists have been able to hear in. If you haven't, please ask me to repeat the questions. I do not mind repeating the same. But Mr. Majok asks, if a boss gives an order that is against the law, should the government advocate follow the order or follow the law? Number 2, how can a government in-house counsel or advocate be protected against from the pressure when giving legal advice or rendering legal advice? And number 3, what should a government advocate do, or rather in-house counsel do, if they see an illegal decision being rendered or being tabled or pushed over in a public office? I don't know, gentlemen and madam, I don't know if you got that question. I think we can start off with the very first question I asked is by Sam Onwang. That can be taken by all 3, if possible. That was the practical skills and techniques needed in maintaining a professional independence.
Thank you very much for that question. What is the key? Because there is no one-stop shop for that. You need to ensure that you understand the law, apply evidence in everything, and also the principles. Most important, you must be faithful yourself. You cannot be conflicted. So maintain integrity and always focus on the institution rather than the individual. And most important, you must be proactive. Listen to the ground. Be ahead of things. Don't wait until everything is concluded for you to show up. You must be part and parcel of what is about to happen, what is happening, and what has actually happened, so that you are not brought decisions to try to sanitize and make them legal, but also understand how to manage political pressure vis-a-vis the public interest. The means always justifies the end. It's not just about where you end, but the means to that end. I think that can be summarized on what you need to do. Thank you.
Thank you. Ms. Nduta, is there any skills you want to share with us?
Yes, thank you, Nicole, and thank you, Honorable Dr. Kanchori. In my experience, I find it very useful to put everything in writing. Reflecting on this, I think about two things. Number one, even on the bench, among our honorable judges, we have room to have a dissenting opinion. And what makes that dissenting opinion valid is the veracity with which you defend it. Provided you have a sound defense from the law, that there's a legal provision for the position that you have adopted, I think you should have the same in writing and be confident to have that stand as your record. Ultimately, my view is that your job is to give your opinion honestly, not to control the outcome. But it helps very much to document everything, because the opinion that is on record is still on the record, whether or not they act on it, whether or not you are victimized for it. But it helps to show that you had a position, that you had a legal basis for your position, that you could justify it, and that it is documented. So practically, I would say, make sure you document everything and that there's a legal basis for the conclusions that you've come up with. Thank you.
Thank you. Memory can indeed fail us and fades, but when you have proper records, it stands the test of time. I agree with you, Ms. Nduta. Mr. Malunde? Yeah.
Yeah. When you are in public service, you should understand, first of all, the government operate in a hierarchical order and bureaucracy, the bureaucratic structure. The problem with the bureaucracy is the limitations. So you should understand you are operating under what capacity and what you are the limitation on what actually you are doing with that one. So the mandate is paramount. You should know where do you deliver the mandate on what you're providing and what are the limit. As I said before, always don't shoulder yourself with the decision will come out. You should always bear in mind you are not a decision maker. So you provide a legal advice, then there is somebody who will make a decision. So you should deliver your mandate at what capacity and deliver, and what where do you deliver the mandate to provide such that ones. And they have been said before, law based on constitutional principles, based on the law, evidence if there is, and avoid the conflict of interest. Integrity is very important within the public service. Then have to leave it to decision maker to make a decision. You have discharged your duty.
Thank you so much.
Maybe in addition, you always must give solicited advice. Don't give what has not been asked. It's very critical in a government institution. Usikue kimbelembele in Swahili. Just ensure that what you give is what has been solicited. Thank you.
So, gentlemen, what we're saying is proper record, and make sure you restrict it based on the case at hand. Do not go over and beyond what is not mandated of you. So I like that the answer that you keep. And also being professional, in my view, also is one of the skills that are required as well. The practical skills that are paramount, and techniques. Just being professional. Do not put even in the conversations that I've been having, rather listening to your presentation, being professional, and remembering who you are as a person, being an advocate of the High Court in your whatever jurisdiction that you are in. You need to uphold the integrity of the law. People will have their change of opinions, but the law still stands. And once you uphold the same, it's easier for you to just maneuver the type of way. So it's being professional, and also documentation is very important. Thank you so much for that, the answers. Allow me to just go to the next, the question that I had posed to you. I think I would like to narrow it down to Mr. Malunde. This was now Emmanuel. He says, I don't know if you got the question. He wanted to file if he's retaliated by his supervisor when he's exercising his protected activity. He was asking, where should he go? What does he sue him on official capacity or on a personal capacity? So maybe you can address that.
Actually, it depends on the circumstance. But as I said, we in public service we are operating in hierarchical order. Then when you are junior, then you are trying to deliver on behalf of the one is above you. Because at the end of the day, the final advice and the decision is an institutional advice. So within the management of, I'm talking about the case of Tanzania, and I buy to be the same even in other country. There are models for operandi within the public service, and even where there's a certain situation, how you can handle it. Don't fight with, and don't take things as your personal issue. Always avoid to be personal, and be wise. You know, in the public services, there is a modality of behaving. Actually, the modality of behaving are coached with the ethics and code of conduct of public servants. So when you have operated very professional, actually the room of conflicting with your superior is very limited, unless you take it for granted that what I feel, that is a person now, what I feel is the right one, and I am able to argue, to fight, whatever the case, so that what my stance should be the stance of the boss, the stance of the organization, is where now the problem starts. I said advice based on professionalism, then you discharge it. You have discharged with your duty. The decision making, let it not be yours. Let the decision maker make their decisions. That is.
Okay. Thank you. I think maybe just to add, I don't know if the question would be, if aggrieved by the decision, if his rights were violated because of trying to uphold the rule of law, does the courts, does he have recourse before a court of law to address the concern when in performing his rights as a duty as an in-house counsel, or rather in-house advocate in his primary duties, but yet the organization, or rather his supervisor, has literally frustrated him? Does an advocate have a right to go to court and say, I have been aggrieved by the actions of my supervisor on this?
Yeah, you know, the public service about the constitution, law, code of conduct, procedures, because how the government actually is do work, and all of this one have provided the mode of operandi. In this situation, how are you going to handle? In this situation, what are your right, what are not your right? So if you understand properly, this cannot be the issue on your side. Otherwise, if you want to go outside the realm of which govern the public service, is where now the problem will start. As I've said, the professional conduct within the public service are regulated with the public service ethics and code of conduct.
Yes, it's true. I agree. We have, in as much as we have various jurisdictions, each country has their own procedures of how to, circumvent rather go around the issue that has been addressed. So we hear you, and thank you so much for the answer. This one I would like to pose it to the question by Machok. I hope I got it right. He asked 3 questions initially. Due to time, I would like to spread this question each one by one. I would like this to start out with Ms. Nduta. And the first question was, if a boss gives an order that is against the law, should a government advocate follow the order or follow the law? The second one, I'll pose it back to you, Mr. Malunde. How does the government advocate protected? I think we've addressed it, but it's just good for affirmation and repeat. And how are in-house counsels being protected from pressure when giving legal advice? Then the other one, I would pass it back to Dr. Kanchuri. It just says, what do they do if they see an illegal decision in a public office? I think that was addressed, but it's good to repeat, just address those questions. So I'll start off with you, Nduta.
Thank you, Nicole. I will answer the question this way. And first, I will make reference to my senior, Mr. Malunde. And he said just a few minutes ago, that as long as you separate yourself from the issue and maintain professionalism, it's very difficult to be victimized. And I paraphrase. Number 2, and I don't mean to belabor the point. However, you would be surprised how many things documentation cures. So if you're given an order, put it in writing. This is what was asked of you. This is what the law says. This is what your professional opinion is. And then again, making reference to what my senior, Mr. Malunde, said, you are not the decision maker. Let them have a record that what they asked may be in contravention to the law, and let them decide. But let there be a record, not just within the institution, but your own personal record, that on this day you were asked this. This is what you were asked to do. You went looking for information and you did your research and you found that this is the position the law provides. And then you take that information back to your superior as respectfully as you can. And in your professional opinion, you say you cannot find a justification for what it is you've been asked to do. However, you note that you are not the decision maker, and leave it at that. Because the problem is, once it is known that you will sell yourself to the highest bidder, it is a slippery slope from there. So there is a way, and people need to learn, especially our junior practitioners, you need to learn to honor your superiors. You can disagree with someone respectfully. You don't have to descend to the level of insults or highly emotive interactions. You can simply do your job and do it well, and then go home at 5 or at 6, depending on when your workday ends. Thank you.
Thank you. Mr. Malunde?
Can you repeat the question? Sorry for. Can you repeat the question?
I'd asked, I think the second one was, how can the government be protected from pressures when giving legal advice?
Okay. There's a constitutional mandate, and I will take it, for instance, in our country. When you are providing an advice, after the chief advisor of the government have been mentioned in the constitution. So all other public lawyer, whatever they are doing on the behalf of a person who have been given the constitutional mandate and protected by the Constitution. That's the Attorney General. And when the issue is about on the prosecution side, there's a director of prosecution. I'm taking the on our side. So there are a person who will be given that mandate by the constitution, and all who are working under him, you're working on behalf of. So whenever you are providing any advice, whatever the case, then you are enjoying the same constitutional protections, legal protection, which have been provided to a person which you are representing on providing that advice. What is important is always you should know public interest is paramount for everything which you are doing within a public service. And you should provide your advice based on the law, mandate you have given, and the limitation which you operate with, ethically, without conflict of interest.
Thank you so much. So everything that we do, everything must be done ethically and professionally. That's what I'm gathering from that question, or rather from the answer. Yes, thank you so much. Dr. Kanchuri, what should an advocate, government, or rather in-house counsel do when they see an illegal decision being rendered in a public office? What should they do?
My first question is, where were you when that decision was made? Because when handling political agency, the lawyer's duty begins before the final decision, not after. So you ought to not just arrived or the visitor in Jerusalem, but you must have been there before that decision is made. But of importance, institutional loyalty, as I said, cannot require participation in an illegality. So you should never be part of an illegality. And I understand the political momentum. It cannot also cure constitutional defects. So you must understand that when you realize. And then again, as my brother said, what is your role? You know, you have a contract, you have terms of your employment. Where does your mandate, what is your mandate? Where are you supposed to reach in your mandate? Most important, the lawyer, in-house lawyer, is also a public servant and a lawyer at the same time. So, and they are guiding principles and policies of your term of employment and your jurisdiction where you need to reach. You need to understand all that so that to know whether is beyond your mandate, is within your mandate to mitigate the legal damages that it will bring to the organization, recommend for mitigation measures, or pass it on to whoever is responsible. So you must understand your mandate and your jurisdiction in terms of your job requirements. Thank you.
Now, probably to add there, from my brother and should have said, you should know you have the duty of accountability. So whatever you advise, whatever you do, you should know you are accountable for whatever you are doing. At the end of the day, you'll be accountable.
And thank you. And this is where the core of the issue happens, where we have seen in certain scenarios where they know, even when they needed your advice, the public organization where most of us practice in may have a decision, or rather they want an opinion they want. And they realize that when they approach you, you give them an advice they do not want to have. And in a bid of trying to make, quote unquote, things run faster, they exclude advocates from even the decision making. So first and foremost, it actually can happen where you can see a decision that has gone through without your consultation. So how then, again, yes, you're upholding, you had given your decision, but you notice eventually in the advanced stages, they proceeded to, proceed without your input. And then now later on, when push comes to shove, when the institution is faced with adverse effects or risks or exposure, they come running back to us and saying, what do we do? So that is a question we need to ask ourselves. What do we do at that particular instance? To mitigate such aspects, how do we go about it? I think this is also in line with a question that had been posed, that you have been excluded from even the decision and giving an opinion. But when push comes to shove, when a decision has been passed, and now the public institution that we serve in is under a lot of legal and risk exposure, they come back to you and say, deal. So how do we go about it at that instance, lady and gentlemen?
Let me come first. Most important duty to government is a duty to its lawful authority. That must be your guiding principle. Not every instruction issued in its name, not to every instruction issued in its name. So whether is your boss, whether is a department, it must be within lawful authority. And as you said, this is where the rubber meets the road, where you are a public servant and now the lawyer guided by the law, the principles and the evidence. So you must draw the line.
Thank you so much. I don't know if there's any one of us who wants to chip in, or I can jump to the next question. I wanted to capture most of our questions. I can see time is not on our side, and I wanted to address all our questions here. But I do not want to cut our panelists. Do they want to add something to that comment I made in such an instance? Mr. Malunde or Ms. Nduta?
When you're operating within the public, you should know there are ethical and non-ethical. Ethical and non-ethical persons. So not every order really represents the public interest. And when you are obeying the order, you should weigh even yourself. Is this order uphold the public interest? Is it for public interest? Is it lawful? Is it in my mandate? And where is my limit to handle this? Obey lawful order, uphold the public interest, ethically, without a conflict of interest.
Thank you. Ms. Nduta, would you want to contribute, or we are good in this particular instance?
Thank you, Nicole. I'll make a short comment and say, and I referenced this in my presentation, you have to decide your flaw in advance. In the middle of a test is not the time to decide where you stand. Integrity is not a matter of public consensus. So even when you go into your job, you have had to have made up in your mind the kind of person that you are, because you will be tested. It is possible to maintain an ethical standard, first with the law of conscience, and then as against the legal provisions. And you're right, Nicole, you can be excluded from accessing the information that will ultimately help you make a good decision. But Mr. Malunde addressed this earlier, and he said, you need to note your constraints. So when you're asked to do something, put it in writing what you are asked to do, the information that was available to you, and the outcome that you extracted based on the information you had. It will be very hard for someone to look at the logical breakdown of what it is you've said and try and use it against you if you note very clearly what was asked of you, what you are given access to, and how you came to the conclusion based on what you had. Sometimes office politics can indeed get in your way. However, it is possible to do your job whilst maintaining your integrity. And the truth is, after a while, your character will be known. And someone can see, Nicole is not this kind of person. This opinion is not consistent with her own character. It's possible for me to conclude that she may not have all the information that was needed to make an informed decision, because one of the characteristics of making an informed decision is proper information, proper and full information. So at all times, protect yourself sensibly, but stay within the bounds of ethics and the law. And you can do that if you document everything, rather than trying to make your opinion fit a predetermined conclusion. That is not the way to go. It's certainly not the way to build longevity in legal practice.
Absolutely. I agree with you in its entirety. I think that has also, your question has also addressed substantially where this is also Sam Owang's and another question, but it has been addressed correctly and aptly. So thank you so much. Now, Mr. Bosire says, how does an advocate working in a public institution say no to the superiors who, even after, let me just scroll down, even just a minute. Sorry, I've just lost that. Just a second. How can an advocate working in a public institution say no to their supervisors who, even after explaining the law, they still want you to act nefarious? So can I pass it over to Ms. Nduta once again?
Please repeat the question.
The question is, how does an advocate working in a public institution, or rather an in-house counsel, say no to their supervisors who, even after explaining the law, you have explained to them the law, the caution, they still want you to act the contrary, if that's what I mean by nefarious? How do we go about that?
I think we have to have a distinction between you as the one providing legal advice and you as the decision maker. Providing legal advice is just a matter of saying, this is what the law says. This is what is available. These are our options. If you are the decision maker, then that's another thing entirely. And I think that is a question that has to be determined in advance by the quality of your integrity. If, however, your work is to provide a legal opinion, not to be dismissive and not to make it look easy, your defense is the law, and say, this is what is available. These are our options. This is what I recommend based on 1, 2, 3. However, the decision is taken out of your hands. And I think it's a fairly safe place to be, because after some time, when it is known that there are things you will not do and other things you will do, you will find slowly that you will be excluded from things that can potentially, once people see that you're not going to play their game, they do exclude you. And in many ways, that can be a refuge. But you have to decide in advance the kind of law you will practice, because it's a big profession and people get ahead in many different ways. So if you've been asked to provide an opinion on something, like the 4 steps I said, understand and make it clear that there are tensions between the required decision and the options available. Make it clear within yourself what your position is, and then understand the law and present the options that are given legally and lawfully, and then let the decision makers make the decision. But I would also ask Honorable Kantori to give comments on this, because I think he's very well established in this area.
Very well.
Thank you, Nicole. just to reiterate my earlier point is give legal advice early enough so that you are able to shape the decision. As my brother said, yours is not to make the decision, but to shape the direction and the speed and the quality of the decision by giving early advice. Be part of the process, be part of the beginning. Sometimes the mistake that the in-house lawyers do is they sit at a corner office and then they wait. Once people have deliberated, they come and bring a spanner in the works. So you are viewed as a hindrance. You are viewed as not politically aligning. But if you are there giving advice way early enough, then you are able to influence a decision. This will mitigate on the political pressure and temperatures. Thank you very much.
Thank you so much. A question has been asked by Mr. Kelvin Koech. Are there any notable public sector advocates in any of the jurisdictions that we can use and make reference to as a case study, and where we can observe and see? Maybe just give an example each if you have. We can start with Mr. Malunde. Is there an example where we can have a look and say this is a case study? This is based on what the public servant that we are an advocate, yes, in the public sector. Is there a case study we can look at, even the participants, and say this is what we should avoid, the pitfalls we should avoid, and the areas we should uphold?
Actually, there are many case studies, but I stand not on the position to say this is one. But there are many, because always the government is advised, always the government make decisions, and when it is the decision is based on the legal advice, it means that there's somebody who is then discharged his duty properly. And when the duty have not been discharged properly, the decision is quite even what will come out of the decisions, especially when the decision were carried properly and it come to turn different from what was expected. But there are many case studies.
All right. And this is now based on the Tanganyika. How about Kenya? Mr. Kanchuri, can you speak about the Kenyan jurisdiction?
You remember, which is part of my presentation, what used to be called the Eric Gumbo case, which was reported in April 2026, which raised allegation that a private law firm was holding multiple concurrent government mandates across the treasury, health sector, and parastatal boards. It was engaged in high-stake international arbitration through non-tender emergency procurement, while simultaneously chairing the board of the Kenya Re, a state corporation that benefited from the same government policy, and allegedly he helped design. So in 2025, a whistleblower alleged that the AG was operating office government business from an office associated with that private law firm. I will not mention it. And that classified family government files, which were marked secret, actually were handled in those premises. And the former LSK president, Nelson Havi, shared the whistleblower's letter. So you see, this was we had a public lawyers within the Attorney General's office who are also colluding with the private law firms, and you could see the politics that it brought, the bad public image. So these are active matters. They are happening. And, it is upon the government lawyers to, as my brother is saying, just maintain the law. You're also a public servant. You have a future. You have a name to protect. And it is always good to live with your shoulders high, because you have a profession also to protect.
It's true. We have a profession indeed to protect. And even as we talk about the tension, the pressure that the in-house counsel go through, there's something that really provoked my mind, and this has also been brought about by this question by Commissioner Jacqueline Ngutia, is just the issue of mental health. You can imagine when things go south, where do we stand as an in-house counsel in our mental health? Most of it, the times you might be going through a lot of pressure that causes us to, lose ourselves mentally. Our mental health is put at risk. So we've gotten a question from the Commissioner Jacqueline Ngutia. She's saying, can we share about possible safeguards for mental health of public advocates, or rather in-house counsel, when they repeatedly face pressure to a point of compromise, where the pressure to compromise their professional judgment or watch unlawful decision proceed despite their advice? So what would you say? She says it may be easy to ask someone to walk away, yet bills must be paid. So it really hits home when you're forced to put yourself between a rock and a hard place. So how do we possibly safeguard ourselves in mental health in such instances? And this one, I would like to posit this will be an input from every speaker on the panelists on this one, because mental health is really important and is critical in this day and age in the legal profession. So I'll start with you, Nduta, then now we can go to Dr. Kanchuri, then Malumbe next. Did you get the question? We're asking, is there, say, possible safeguards for mental health, or i.e. in finding a community in public service, or for public in-house counsels when they repeatedly face pressure to compromise their professional judgment or watch unlawful decisions proceed despite their advice? I don't know if you got that question.
Please repeat the question one more time, especially towards the end.
Okay. She asks, are there possible safeguards for mental health? Okay. An example could be finding a community. Do we need to find a community to address the mental health issues for in-house counsels when they are faced with a lot of tension, whenever they repeatedly go through the vicious cycle of when you can see they have been called, there's a lot of pressure for compromise. And yet it's a repeated cycle. It's not a one-off and sit pretty and life goes on. It is a continuous process. You have been told, continuously go contrary to your legal profession and beliefs and your principles. How do then I know when it's a repeated cycle, it affects your mental health. So is there possible safeguards to ensure and protect us, the legal counsel on place who work in the public sector, from having to, you can easily lose yourself, for lack of a better word. You can easily lose yourself. In Kenya, it's very possible. I also believe the pressure is the same all round, be it in Uganda, Tanzania. The pressure in public institutions is still the same. So it's not an isolated case. It's a whole scenario in the public sphere for all those advocates, or rather in-house counsel practicing there. So the question is, how do we safeguard, or do we have any safety measures in place for mental health when we are for in-house counsels in such scenarios?
Okay. I will take a stab at giving an answer based on what I think, what I aspire to, and what I have practiced, and what has been working for me personally. This is not medical advice. I think going into any engagement, be it professional or personal, you have to decide at the outset who you are. As they say in the fitness world, you choose your hard. The cost of practicing ethically is high. So is the cost of practicing without ethical boundaries. That is standard. Either way, there is a price to pay. So you need to have made a decision. Number two, I think there is a lot of value in cultivating inner fortitude, because many aspects of life are very challenging and you need to have the inner resources to build that. If you have a faith practice, and I do, you lean into the resources of your faith practice. Number three, I think one should not underestimate the outlet that is exercise and physical movement. It is low-hanging fruit. You can run, you can take a walk, and it helps to get rid of some of that tension. It will not solve the problem, but it will remove it from within your body. Number four, you must have one or two people that you can trust to talk some of these things through with you. I think number five, create a separation as much as possible from what you will carry from work and what you take home. This is not about living compartmentalized lives, because it doesn't really work. You cannot be one person in the office and one person at home. But you have to remember that what you're doing at work is providing the best possible legal advice. And then you let it be. There is a grind to life that requires building ways to build fortitude. Mental health is a big deal. And I think I like the conversations around mental health, because they acknowledge that there is a mental and an emotional cost to the work that we do. However, I think there is something to be said for building inner resilience and inner fortitude, because I have not yet encountered an aspect of life that is stress-free. I hope that is somewhat helpful, but this is what I try to do in my life, and I think it works.
It is. It's very, very helpful. Maybe we can get feedback from Dr. Kanturi, then Mr. Malunde.
Asante sana. I think this is now the real discussion, because a public lawyer, being a public lawyer is a delicate position in itself. So your mind must be prepared. That is not just another position, maybe an accountant or a procurement guy who has already an outline of what to follow. You must realize that when you are there, or when you are going there, you're going to a delicate position where you'll be balancing both public interest, political urgency, institutional pressure, and your constitutional duty. What in my previous task was to form a group of like-minded people within the organization. You might be several or even similar organization out there where you form a group together and share the challenges. Sometimes I saw a video the other day of a lady, sorry to use this example, who went out to discuss his husband's problems, only to realize that compared to what she has had, he has an angel. He came back and started washing the husband, feeding him and all that. So if you share your challenges with your colleagues and your peers out there, it is a way to ventilate and even realize, oh, I'm doing better, or I'm worse, or it's not as bad as I think. So, and finally, just to realize that your area is all about the ethical campus. You are just operating within what is ethical and what is legal. Don't find yourself or put yourself in many problems where you are conflicted. Your mouth is too full for you to speak. You are already soiled. They say one who has clean hands is the one to approach equity. You must have clean hands so that you have the moral authority, the legal authority, and the ethical authority to be able to defend your case. That will give you a peace of mind. That will give you you know that I have done what is supposed to be done. You've done what is right. So they can have their way, but you've had your advice. Thank you.
Thank you so much. Mr. Malunde?
Yeah, actually what I can say is you are public servant, but also you are part of the society. And so far you are serving the government, you should know that or whatever you are doing have something to do with the society, have something to do with the public. And discharge your duty properly, and then be part of the society. Be part of the society, interact with the society, and stress management is very, very, very crucial. You know, when you have discharged your duty, whatever pressure was, whatever the way it come into your size, then once you leave the place, and then you go with the same, even you are at home, you don't have time to interact with your friends, your colleague. You always interact with what actually you have done. Then at the end of the day, you're collapsing yourself. Stress management is very, very crucial when you are discharging public duty.
Thank you so much. Indeed, it's very important that there's actually need for us to, I think this is a proposal we can actually table to the East African Law Society, that we can have a forum. If it's now in Kenya, you have your forum, then in your different jurisdiction, and then now meet and discuss. Probably the issues that you're raising are similar. I speak of Kenya because that is where I come from. If it's Kenya jurisdiction, we have a forum where we can ventilate and have, a forum just for the in-house counsels for practicing in public sectors, where you can just converse and see how we're doing and share answers, share, maybe, once an issue is shared, it's half a problem solved. So you can imagine that with that in mind, there'll be need for us to, share and ventilate such an issue, and have a forum and do exercise to keep fit as well, and to also ensure that when push comes to shove, you can live. You can live. I think if it's so that you do not lose your mental health, you can live. So I think that's the key take-home points that I have, or rather I picked up from that question. And with that, thank you so much, panelists. Thank you so much, all the participants, for the amazing questions that you have posed. We really appreciated it. And we look forward to having more engagements such as this in future. And allow me to, once again, I say thank you. And to once again to the East Africa Law Society for this opportunity just to ventilate the issue at hand, as in the public sector, for all advocates practicing there. And thank you so much. Allow me to pass it over to Gabriel if he's still there. I don't know.
Yeah, very big to you,
Yes.
Nicole, our esteemed panelists, the Honorable Dr. Kanchori, Daniel, Mr. Lucas Charles Malunde, and to you, Ms. Nduta Njenga. Thank you for that very wonderful session. It's really been eye-opening, eye-catching, and rightly said, Nicole, at the East Africa Law Society, we value opening spaces that encourage discussions, and that's why our public sector committee of the ELS does exist. And indeed, we anticipate that at the 31st annual conference and general meeting in Zanzibar, we'll be having a discussion that is spearheaded by our lawyers working in the public sector. And as such, I encourage all of us to register and join the bandwagon that is coming to Zanzibar in November to further these discussions. It's really been an amazing session. We've taken down very key considerations that we ought to spiral upwards in terms of sharing with the relevant stakeholders within the sector on how to make the spaces more accessible, but also bring about increased comfort for members that are practicing in the sector. So on behalf of our CEO, Mr. David Sigano, our President, Mr. Ramadan Abu Baker, and the entire team at the Secretariat, would like to thank you all for making time and for joining this very wonderful discussion. We will share all the presentations that have been made this afternoon and a recording of this session to your different email addresses, but also we will follow up with a subsequent discussion. As you can see, it's been quite insightful, like majority are saying in the chat room. And it's invited colleagues from as far as Eswatini to come and join this conversation. So we wish to expand these frontiers, and we encourage you to look out for more of our capacity building sessions next week that are happening on Tuesday, Wednesday, and Thursday. So from us to you, we wish you a very lovely afternoon ahead, and till we meet again, we thank you, Nicole, for that wonderful moderation, and allow me to now formally close the session. Goodbye until we have a further discussion. Stay blessed and have a blessed weekend. Tomorrow being Friday, Honorable Dr. Kanchori.
Thank you.